Hi, and welcome to our podcast. Thank you so much for taking the time to listen to the podcast. As you all know, the Canadian Securities Administrators and the Investment Industry Regulatory Organization of Canada, also known as CSA and IIROC, recently published guidance for crypto asset trading platforms. And to make it more complex, the Ontario Securities Commission, also known as OSC, advised that all crypto platforms are required to get in contact with the Commission to begin discussions as to whether their platform is required to comply with the guidance from the CSA and IIROC. Now, there are so many questions related to this new guidance, so we hope to answer some of those questions for you today. And we also hope to introduce you to the expert in the field who can answer any of your specific questions that you might have after the session. In addition to our expert, we have myself, Marcelle Dadoun, and Adam Feldman. We are consultants from the AML shop, and most of you have probably worked with us in the past, but if you have any regulatory questions related to AML after the session, please feel free to reach out to us. On that note, we would like to introduce you to Matt Burgoyne. Matt is a partner and the head of the cryptocurrency blockchain group at McLeod Law. Matt acts for a variety of businesses and entrepreneurs, mainly in the cryptocurrency and private lending industries, including but not limited to cryptocurrency exchange platforms, issuers of digital currency, including stablecoins, cryptocurrency miners, cryptocurrency investment funds, mortgage investment corporations, syndicated mortgage entities, and mutual fund trusts. Matt provides securities law, anti-money laundering law, and general legal advice to cryptocurrency and private lending clients. And we are super excited to have Matt with us today to help give us an overview of the CSA IIROC guidance for crypto asset trading platforms and what we should be considering as next steps. Over to you, Matt. It's great to have you join us.
Thank you, Marcelle, and Adam. Thank you so much for having me. It's a pleasure to be a part of this. This is an interesting time right now as far as Canadian crypto exchange platforms go and Canadian regulation. We're really at a crossroads, I feel like, with the Canadian Securities Administrators and the provincial securities regulators. And as far as compliance is concerned, I'll just say historically there hasn't been a lot of enforcement action against crypto platforms in Canada. The industry was kind of waiting for regulations to come out, and there was a request for comment last year, a comment period where the regulators were testing certain concepts, and now they've published on March 29th the CSA staff notice 21329. Where they talk about the existing regulations and how those apply to crypto asset trading platforms, and maybe some exemptive relief that could be granted to certain platforms. So I'll talk in broad strokes today about some of the concepts that are discussed in the notice. So I'll talk about the concept of dealers as introduced in the CSA notice, marketplaces, and then we'll talk a bit about custodial, the concept of a custodial platform and non-custodial platform, security tokens, crypto contracts, and then we'll talk about next steps and what platforms can expect in the future. So in the notice, they being the CSA and IIROC, it was a joint CSA IIROC notice that was published. So the CSA and IIROC came up with this concept of a dealer platform. What they mean by a dealer platform is a platform that facilitates the primary distribution of security tokens, and a platform that is a counterparty to a trade of a security token or what they call a crypto contract. Cryptocurrency contract is basically a derivative type contract entered into between the user and the platform. If the platform is custodying the user's crypto and the user has a right to the crypto, that's what they're holding. The securities regulators have seen that as a derivative type contract. So even if the platform is not distributing security tokens, even if it's just distributing or enabling trade of Bitcoin and Bitcoin Cash, Litecoin, Ethereum, the big coins with the most volume. It can still be, the platform can still be a dealer platform. So dealer platforms are platforms that onboard retail clients, and that dealer platforms custody, they offer custody of assets on the platform directly or indirectly through a third-party custodian. So, to be a dealer platform, to be considered a dealer platform, you can't be in margin or leverage trading. You can't offer those things unless going forward, unless you're registered with IIROC and you're registered as an investment dealer. That is so. So that's kind of what a dealer platform is. It's a platform that has an agreement directly with the user, and the platform is selling the crypto to the user. And so the marketplace is more of like a broad, kind of almost like a clearinghouse. So a marketplace is a platform that brings together multiple buyers and sellers of security tokens and crypto contracts. And so they bring multiple orders together, and they use established non-discretionary methods in which orders for the security tokens and crypto contracts are traded. So if you have a platform that has that enables orders between multiple buyers and sellers, and they're brought together, within a third-party facility, and the interaction of those orders results in a trade, then you're probably talking about a marketplace. So marketplace, just think of like, where, again, matching multiple buyers and sellers together, where, a contract can be made and an order can be made, which results in a trade between a specific buyer and seller. So just really generally speaking, those are the concepts of a dealer and a marketplace.
So, Matt, sorry
yes.
to interrupt. In a marketplace, would that be like a peer-to-peer exchange platform?
Yeah.
Like a local Bitcoins type of platform?
Right. Yeah. Yes. Because in that case, right, peer-to-peer. So when you're when you think of peer-to-peer, that I think is what they mean by marketplace, because again, it's matching a buyer with a seller.
Perfect. Thank you.
Yeah, and not the buyer with the platform itself. So I'm just going to talk about this interim approach now, and kind of olive branch that the CSA and IIROC have given to crypto platforms. And they said, if for dealers, if you're a dealer platform and you deal in security tokens or these crypto contracts, if you rely on a prospectus exemption, because there's two concepts in securities law, the prospectus requirement and the registration requirement. So they're saying, look, dealer platform, if you're complying with a prospectus exemption and you don't offer margin or leverage trading, you can be designated as an exempt market dealer, a restricted dealer, or an investment dealer. And if you solicit trades with retail investors, you can be subject to this interim approach. So as long as you've taken steps to begin registering your platform and you're not offering margin or leverage trading, there's a way forward that permits you in the interim to continue to operate your platform until you become regulated long-term in a more long-term kind of final method, if you will. So the CSA has also said for dealer platforms that it may, on application, consider discretionary exemptions from existing rules where the dealer platform is showing that it can comply with the policy intent of existing regulation by some alternative means. So if you're kind of following through in the spirit of the law, and you don't quite comply with every single requirement of, for example, an exempt market dealer, if you register in that registration category, then that's okay. The CSA and IIROC are saying, at least apply and meet with us. And this includes IIROC too. They're expecting people who solicit retail individuals to register with IIROC. They're saying just contact us. You can operate in the interim. We understand that it takes time to register like this, and it's going to take time in order to maintain your competitive advantage. The CSA and IIROC will let you continue to operate as long as you've made an attempt to contact them and are in the queue to be registered. So do you guys have any questions so far about that part?
I mean, not directly. That was great, Matt. Just want to ask you, as far as that OSC deadline for April 19th, would you talk a little bit about who that might apply to?
Sure. So yeah.
Sorry, I don't mean to jump in, but we're coming up to that in just a second, Adam. In the queue of the slides. Can we continue talking about the exceptions that we started talking about, and in the next slide we'll be talking specifically about that April 19th deadline.
Sure. So just quickly, marketplaces, if you're a marketplace, you have the same interim approach option that's being given to you by the CSA and IIROC. So marketplaces can, as long as they reach out and either themselves or their legal counsel and are attempting to begin the registration process, and are going to register in good faith, and they can continue to operate. And so the marketplaces, as well as the dealers, there's some exemptive relief that they could possibly offer marketplaces as long as they're complying with that policy intent of the existing regulations in some alternative way. It gets a little complicated with marketplaces because they themselves can also be registered as dealers. But suffice to say, there's two main categories: dealers, marketplaces. If you're a crypto asset trading platform, unless you're not custodying crypto, which I'm going to get to next, you probably fit within either a dealer or a marketplace. So let's get in, because I know we're kind of short on time here, to the custodial versus non-custodial. So I want to bring this up because I don't know that they directly mentioned it in the CSA notice, IIROC notice that came out on March 29th. But last year, the CSA, and I think it was IIROC as well, published a notice on just trading platforms, crypto trading platforms. And they introduced this concept of immediate delivery and custody. And so the regulators basically said, if you're a platform and you're custodying crypto, and if you own the private keys and the custody of someone's cryptocurrency, you're probably a dealer or a marketplace. But if when a buyer purchases crypto and there's an immediate delivery of the crypto to the user right away, and that's built into your agreement, your user agreement with your users, and that happens every time. So with regularity, so there's always immediate delivery. That you might not be dealing in securities. So I think it's really important for platforms to be aware of this. But you can't be trading in security tokens as well in order, if you want to get outside of the scope of a dealer. So if you're only trading in Bitcoin and Ethereum and maybe Litecoin and Bitcoin Cash, and you're immediately delivering crypto to a user's wallet, you might not be a dealer. And in fact, the CSA and IIROC use that as an example in their notice that they published last year. So that provides kind of a way for platforms to not be considered dealers or marketplaces. Again, if they're not trading in security tokens and they're immediately delivering crypto to a user's wallet, and the user has control of the private key, that's very important. Otherwise, you're probably a dealer or a marketplace, according to the provincial regulators. So do you guys have questions on that?
No, I don't. Adam?
Yeah, I guess my question here is, so let's say one of our listeners here thinks that they are not a dealer or a marketplace because they fall into non-custodial and non-security tokens. Should they still get in touch with their local securities administrator to make sure that they are in fact exempt from the regulations?
You know what? I mean, I would always recommend that people call their lawyer in that case if they're like on the fence as to whether or not they're custodying crypto and they're not trading in security tokens. Because I know, like, you know, there's a lot of confusion over whether stable coins are considered securities in Canada. My experience is the regulators have, you know, surprise, surprise, have considered them to be securities. That's my own personal experience with one of my clients. You know, despite our legal arguments to the contrary. So I mean, you can call your regulator, but always call your lawyer as well. I would, you know, recommend if people kind of accept the fact that they're running a dealing platform or a marketplace platform, then by all means call the regulator or your lawyer. But if you're on the fence as to whether or not, you know, you even are a dealer or marketplace, maybe you should call your lawyer to get a determination first before you contact the regulator.
Yeah, so that, I mean, that really takes us into the next steps, right? And what do we do now that this guidance has been published, now that we have this looming deadline ahead of us that Adam was talking about earlier, this April 19th deadline by the Ontario Securities Commission. What are the next steps, Matt? What do people need to know?
Right. So, you know, it was a little confusing. So the CSA and IIROC came out with a notice, and then at the same time, the OSC came out with a local staff notice that applies to issuers of securities that are who have a head office in Ontario. So, you know, if your platform is based in Ontario, or if you're, you know, a platform that's based in another province, but you've got a lot of Ontario users or a certain amount of Ontario users, you know, you're beholden to the OSC, and that notice states that you have to contact them by April 19th. So I would recommend strongly that platforms contact their legal counsel, or you know, if accepted the fact that they're platforms and dealers, they can contact the OSC directly by April 19th. I think, based on my experience in the industry, I've been doing this for about almost 17 years, that we will see enforcement actions in the next few months. That wouldn't surprise me at all. You know, I understand there are a lot of, for example, MSBs, as Marcelle and Adam, you're aware, are registered in Canada that are operating dealer platforms. So I wouldn't be surprised, you know, if we see some enforcement action. Because so next steps, just, you know, be aware and do the next right thing, because there's no more grace period there after the 19th. That's it. They're clear. They're not going to really entertain arguments, legal arguments anymore to the contrary of why someone isn't a dealer or platform when they clearly are, and you know, in the regulators' minds. That point is past. That ship has sailed. So yeah, contact your lawyer or the regulator directly if you're in Ontario before the 19th, or if you have a lot of Ontario clients. Otherwise, you know, as far as the other provinces are concerned, they'll expect you to, you know, do the same thing and take action to become registered, or call them and start the discussion. So.
Very good. So just wanted to say that there in the past, we have heard of some exemptions that have taken place, and I know you have some experience with a few of them. Just wanted to hear from your experience what some of those exemptions might be.
Sure. So Wealthsimple, I think, is the largest, the most prominent example of a platform that has applied for relief and has been granted relief. So, you know, if you download, I guess, Wealthsimple Trade, there's a crypto wallet that's available. So you can buy and hold and Bitcoin, and I think it's just Bitcoin and Ethereum, but they've imposed a limit of $30,000 worth of crypto per year per user. So that's an example of, and that, you know, a restriction that was put on. So they're allowed to, Wealthsimple's allowed to deal in crypto, but under certain conditions. Now, that's, you know, the regulators always preface each decision by saying this shouldn't be viewed as a precedent for every circumstance. Every circumstance is going to be unique, and it's going to be, you know, it's going to turn on its own facts. So I would expect that, you know, other different orders are going to be, they're going to have different restrictions. Finhaven Capital, kind of a lesser known example, but they've been operating in BC for a while. So they operate a crypto trading platform where accredited investors, so those are high net worth individuals, can trade with each other privately on this platform, and they can what's called operate in a secondary trading market. They can trade amongst themselves on this platform. And that's a kind of a trial project for Finhaven that I believe there's a time limit on that. But again, that's an example of a platform that received some exemptive relief and is being allowed to continue to operate. So Finhaven and Wealthsimple. There are some other examples. I think we're not going to have time really to get into those right now. If your lawyer practices in the space, they would be aware of those other cases as well, and can point to examples of relief granted in those cases.
Yeah, for sure. And thank you so much for giving us this overview. The clear message is get in touch with your lawyers, or if you don't have internal legal help or external legal help, reach out to the regulator to ask the right questions and get the discussion started, so that you don't fall under scrutiny of the regulators should you be qualified as a dealer or a marketplace or whatever, that you're not facing the regulatory penalties for not being properly registered. Such a great overview, Matt, and Adam. Thank you for participating and adding the questions. Thank you so much for listening in to the audience, to whomever might be listening. If you have any further questions related to this topic, please don't hesitate to reach out to Matt directly, or to reach out to Adam and I at the AML shop for any AML regulatory questions. Our contact information is on the screen at the moment. We're available to help and answer any additional questions that you might have. So thank you so much for your participation, Adam and Matt. Look forward to having further engagements like this in the future.
Thank you again for having me. This was great. Thanks a lot.
Great, thanks.
All right.